Let's go to this guy right here. Good morning, everybody. Give me a second. Let me get me a bottle of water. Excuse me. All right, let me check the chat. Make sure everybody can hear me because before I begin, I want to make sure that everybody can hear me. Let me go and pull up this case from yesterday. It's about 4 pages long, so I'll read that case. The other case, I'm not going to read it. It's too long. It is 80 Kentucky, page 656. Right there. All right. This is the case that I actually read yesterday. Oh, 6 pages long. Okay. All right. Let's go back to the chat. Shannon Brooks, thank you and welcome. I really appreciate it. I really, really appreciate it. Thank you so much for joining and supporting my membership. What up, bro? I hear you well. Ready for that? Okay. What's good, AC? Good morning, man. Good morning. Good morning. Hope everybody enjoyed their Friday, and I hope everybody enjoys their weekend. All right. I'm gonna go ahead and I'm gonna start the topic because this guy don't know what he's talking about. And look at all these subscribers he has. He has 147,000 subscribers, and I just can't believe that we just so lost like this. I mean, I'm gonna read some of this stuff what they saying. Stay in school, kids. Get an education. Don't grow up stupid. He can travel straight to a jail cell. You got arrested for driving without a license, and he's sitting in the car while he's doing his Zoom court date. Where are these people's brains? Look at this stuff, man. Just all types of. Look at this. I kind of wish a judge and DA troll a sob turd. Wish a judge, okay, sob turd. Say it's under Admiralty law, and they charged with going 55 over 10 knot zone, blah blah blah. Just look at all this stuff, y'all. Just look at all this stuff. Man, don't know this man. This man do not know what he's talking about. I don't think he represents himself out to everyone as a student of law, but he should. If he's going to be on here making videos like this, then he should be studying like I do, because I do a lot of reading. As a matter of fact, I'm gonna give y'all a case to read. This is a case I'm reading right now. Not that one. Right. I think is it not that one? It was another case. It's out of Nevada. Yeah. This is a good case, y'all. I gotta finish reading it. But it's a really good case. I'm gonna give y'all this case citation, let y'all go and read it. Um, if I'm not mistaken, some people were trying to, well, I think if I'm not mistaken, I want to say private citizens. I'm not really sure because I didn't read the case all the way through, but they were trying to create them a bank. And the legislature, I'm not sure if it was a state legislature or if it was some sort of municipality, essentially tried to deny them that right or whatever. Um, the key word in here that I'm looking for is this right here, though: vocation. That's the key word that I'm looking for in here because it ties into this right here, where it says the right of a citizen to pursue any of the ordinary vacations on his own property and with his own means can neither be denied nor unduly abridged by the legislature. We're gonna get to that case in a minute. That's Ex parte Dickey again. We'll get to that in a little minute. Let me give y'all this case. This is another good case. I don't want to confuse nobody though. There's a lot of good cases out here, man. But you got to go and read these old cases because these old cases they establish the principles in solidifying why the judiciary of today, well, not all of them, but some of them are ruling the way that they are ruling, because some of these people are just they just committing treason. That's what they're doing. Where is it at? New Hampshire, Nevada. Okay, Nevada. I got to find. Now, I'm gonna give y'all this case citation because I didn't download it yet. I'll do it like this. Let's see what this case citation. Okay, this is a Nevada Supreme Court case. It is 33, volume 33, Nevada, page 333. It's in from the year of 1910. I'm not gonna save it yet, but let's go ahead and get to this video, and then I'll go ahead and start talking about some other stuff. I'm sorry, I'm kind of all over the place a little bit, and I apologize for that.
Video. Today, we have the return of a Kansas sovereign citizen who recently found himself in quite the dilemma when he requested and was denied an in-person jury trial over Zoom from Texas. Now, that's not typically how jury trials work, as those are pretty much always in person. Well, he's found himself in another conundrum as he apparently received another traffic ticket while traveling through Kansas for that jury trial. So let's begin.
All right, the next matter is State versus Isaiah Kervin, 24 TR 17. There's a name of Isaiah Kervin on the screen. Please turn on your monitor.
I'm here.
Mr. Kervin, is the headgear you're wearing a religious item?
It's a cap. I'm outside. It was snowing out here. I'm in Oklahoma City. I'll take it off in a second. That's why I got my jackets on. Yeah, it's kind of cold outside. No problem.
All right. This is your first appearance. We were scheduled for an earlier date. Mr. Kervin did not appear at that time. A 30-day suspension letter was ordered to be sent. Mr. Kervin apparently contacted the clerk's office following at some point intervening and requested hearing. So we're here today for first appearance. Mr. Kervin, you are charged with driving without a valid driver's license, no DL. That is a Class B non-person misdemeanor. A B misdemeanor is punishable up to 6 months in the county jail and a fine not to exceed $1,000. Not saying that's what the penalty will be, it's just what the maximum available under Kansas law. You have the right to a trial if you are subject to a jail sentence, or if that's a possibility, then if you wish to have an attorney but could not afford one, you can apply to the court. If you met the financial guidelines, then I would appoint an attorney to represent you. However, if a person is not facing a jail sentence, then they're not entitled to court-appointed counsel.
Well, he is looking at jail time, so he does qualify for a court-appointed attorney. Now, whether he's smart enough to take it or not, that's not up for debate neither, as this guy is dumber than a bag of dicks, and he'll be representing himself. But you don't have to take it from me, as you're about to get it directly from the horse's ass.
You understand?
Listen to this man. This guy clueless. All right. You are not, this is just my own personal opinion. All right. So obviously, I'm guessing that was his own personal opinion, but I'm not hiring an attorney. There's a high probability that I will probably never hire an attorney unless I reasonably believe that I need one. But generally speaking, I can handle most of this stuff on my own. So if you believe that you are competent to litigate your case on your own, you do not have to hire an attorney if you don't want to, and there is nothing wrong with that. Okay? There's nothing wrong with that. Oh boy, this guy here, it ain't even got good yet. Y'all just wait.
And you're right, sir.
I do. Yes, sir.
In a moment, I'm going to ask how you wish to proceed in regards to a plea. Right now, do you have a plan in regards to an attorney? Are you hiring an attorney, asking the court to appoint, representing yourself?
Represent myself, Your Honor.
Very well.
All right, I'm gonna stop right there. The reason, in my opinion, that you don't hire an attorney, because they are not going to go into these administrative agencies masquerading as court and make these arguments that you're making. They're not going to do that. They're just not going to do that. You can forget about that. They're not going to do it. Let me go back and check the chat just to make sure the volume is and everything is good. All right. Is that giving jurisdiction taking off his stocking cap when it acts? In my opinion, I would say yeah, because he really didn't have to take off his hat. Like, you in your car, fam. You got to take off your hat. Nothing true is popular, and nothing popular is true. Ooh, that was really good right there, man. That was really good. I like that. Very well said. Y'all hit that like button for me if y'all don't mind. Hit that like button. Let's get back to the video. I'm gonna start schooling him in a minute.
Mr. Curvin, you looks like you're 33 years old. So, absent some other compelling reason, you'd be able to represent yourself. If you wish to, I'm going to ask what your plea is. If you wish to have a trial, if you wish to, I don't know if you qualify for a diversion, if you wish to try to get the case resolved either through counsel or yourself with the county attorney's office, any of those things, then the plea should be not guilty. If you choose to plead guilty, then we would proceed to sentencing. I would hear from both parties and a pronounced sentence. If you plead no contest, that is then if the state were to present what we refer to as a proffer, a person who's pleading no contest are not challenging the charge, but they're not pleading guilty per se. If there's a proffer that supports the facts that would result in a guilty verdict, then that person would be found guilty and we'd proceed to sentencing in the same manner as I described before. With those things in mind, how do you wish to plead? Guilty, not guilty, or no contest?
Are we on the record?
Yes.
So on the record before I make a plea, I'd like to simply state that I do not understand the nature and cause of the action in regard of the elements of my persona jurisdiction, the venue, and the nature cause of action until the prosecution has properly alleged that before me, and therefore I'm not able to enter a plea until then. I'd like to know if it's going to be if I'm going to be tried under common law, or is it going to be under maritime admiralty law?
Well, it's not under maritime admiralty law, since Kansas is landlocked and you didn't allegedly commit your crimes on the high seas. And it's not—
Stop right there. This man don't know what the hell he talking about. He don't know what he talking about, y'all. This man don't know what he talking about. All right. So let me school y'all right quick if you don't know this. All right. It does not matter if a so-called crime happened in water or on land in order for admiralty jurisdiction to attach. It's the nature of the contract. If the nature of the contract is maritime, then as a matter of law, the admiralty jurisdiction is going to attach. All right, this is an administrative hearing. It's not common law because there are no statutes in common law jurisdiction. It's not equity because there are no statutes in equity. Admiralty courts are civil law courts. Civil law is statutes and codes. Let me show y'all something, man. I ain't gonna show y'all this. I'm not even gonna show you the whole video because it's just too long. Let me go on my YouTube channel again because I did this months ago, y'all. Months ago. Months ago, I showed people this stuff. Where is it at? Right here. We're gonna go down. Y'all got to go and watch some of my old videos, man. You have to go and watch. Where are we at? It's gonna be in, what is video at? Right here. This is the video that you need to go and watch. Go watch this video. 20 minutes long, And it's going to prove to you everything that I'm saying, that these are not courts. They're administrative agencies masquerading as courts. That is what they are doing. They're corporations. A lawsuit has been filed against this man, and the state, under the guise of the city or county or wherever he is claiming to be the injured party. That's what's going on. A lawsuit is going on in here. They're suing him for breach of a statute. You think I'm lying? If this guy asks, because I've done this before, if you ever ask these people who is the injured party, they're either going to look at you like you're stupid, they're going to say it's not them, or they're going to say it's the state. If they say it's the state, which is generally that's what they most of the time that's what they'll say. Most of the time, if they say it's the state, then I want you to go through discovery and see if you can issue a subpoena to the state of wherever he is, and see if the state will come in and take the stand and testify. This is how stupid these people think you are. You need to go and watch this video right here. They're not courts. They're administrative agencies. I don't care if they call them courts. If they are created by statutes and they're following statutory procedures, they're administrative agencies of the legislature. That is what they are. And administrative agencies are a part of the executive branch of government. They do not have any legislative or any judicial authority at all. This man don't know what he's talking about, man. He does not know what he is talking about. The nature of the action is admiralty. I'm of the opinion, and I'm 100% sure of that. And the reason why I say that, I went to court before, right? I'm in a so-called circuit court. All right, we're on the record, all this stuff. And I look at this so-called judge, and I ask him, for the nature of this action. What jurisdiction is this case being prosecuted under? He looks at me in my face, and he say, it's not common law jurisdiction. And he didn't say nothing else. And I know it's not equity, because equity does not have a criminal jurisdiction. There's only two that have a criminal jurisdiction, and that is common law and admiralty. That's it. This man do not know what he is talking about, and you need to stop listening to him. He don't know what he's talking about.
Not under common law, as Kansas has a set of revised statutes that clearly define your behavior as criminal and the punishments for your crimes. And just to be clear, you're being charged under Kansas statutory law, Article 2, Section 8-235, which...
All right, I'm going to stop right there. Then I just told you administrative agencies follow statutory procedures and enforce statutes, and they are members of the executive branch of government. So let me give y'all some more examples of what an administrative agency is. The city of Atlanta is an administrative agency. A county is an administrative agency. The school board is an administrative agency. Child Protective Services is an administrative agency. The Department of Human Resources is an administrative agency. The Department of Transportation is an administrative agency. The Department of Motor Vehicles is an administrative agency. The Police Department is an administrative agency. The Sheriff's Department is an administrative agency. Is this making sense for y'all? Because it makes perfect sense to me. They are all administrative agencies. Every single one of them. All of them. And so is this so-called judge. He's an executive administrator impersonating a judicial officer, because he has zero judicial authority at all. He don't have any. Because the sovereign people of wherever this man it was Kansas, the sovereign people of Kansas did not give this man judicial power. He didn't get that through the Constitution. He got that through the legislature. So this is what they do in administrative agencies. The legislature will create these administrative agencies, and they will authorize them quasi-legislative authority and quasi-judicial authority. I don't call it that. I say illegitimate legislative authority and illegitimate judicial authority because they don't have any. How you going to delegate something that doesn't belong to you? It's not yours to delegate. It doesn't belong to you. The ultimate lawmaking power does not belong to the legislature. The ultimate judicial power does not belong to the judiciary. The ultimate executive power does not belong to the executive. It belongs to the sovereign people of Kansas, and they can, at will, whenever they want, write their government out of existence right now if they want to. They can do that because they're sovereign. They can take away judicial immunity right now if they want to in Kansas by putting it in their constitution. They can nullify every Supreme Court decision in Kansas at will whenever they want because they are sovereign. Anyway, this man get on my nerves. This man do not know what he's talking about, y'all. He does not know what he is talking about. I'm not even reading right now. This is off the top of my head because I've already read the cases. Let me get back to this video.
Clearly states that an operator of a motor vehicle on a Kansas roadway must have a driver's license.
Get online in minutes. Web.com's AI builder makes it easy. Simply tell us some info about your...
Can you speak up a little bit? It's difficult to hear you.
I got my headphones on. Did you hear what I said, or just what part did you need to?
I heard part of what you said, so.
Okay. I was saying, for the record, I did not simply understand nature and cause of action brought against me, with regards of the elements of our personal jurisdiction, and also the nature and cause of action until the jurisdiction, the prosecution has let me know what they were trying to underneath, so I can let you know what I'm going to make my plea. I'm not really sure if it's under common law or is a maritime amity law, so I can know how to defend myself, and then I get into my plea.
All right. Have you filed a motion for?
All right. One more thing. The reason why you want to know what the nature of the action is because there are different pleas that apply to different jurisdictions. So let me stop a little bit and explain this to y'all about what has happened. So I would say anywhere from 100 years ago to maybe a little less, maybe 70 years ago or something like that. These so-called courts were all separate courts. Common law, equity, admiralty, and maritime. Admiralty and maritime, they were always the same, if I'm not mistaken. So generally speaking, they were always in the same building. But common law and equity was not. So what they did was they have merged all four of these jurisdictions into one building and into one so-called judge. So you don't know which hat the judge is wearing, the so-called judge anyway. You don't know who you're dealing with. You don't know if you're dealing with a chancellor, which is what they call judges in equity. You don't know if you're dealing with an executive administrator, which is what they call so-called judges in admiralty, or an admiral. That's another term that they call them, admirals. And you don't know if you're dealing with a true judicial officer or peace officer. If I'm not mistaken, peace officer is what they call I can't even get the word. I can't even get the word out, y'all. It's on. I can't even get it out. It's on the tip of my tongue, and I can't even get it out. Anyway, long story short, they merged all these courts together. All right. But also, when these courts were separate, each of these so-called courts, they had their own rules of procedure governing how to prosecute cases in each of these so-called courts. But they merged all of that stuff together into one. All right, so they don't call it the rules of equity procedure or equity rules no more. They don't call it the common law rules no more. They don't call it the admiralty rules no more. This is what they call it, y'all. The federal rules of civil procedure, the federal rules of criminal procedure, the North Carolina rules of civil procedure, the North Carolina rules of criminal procedure, the Alabama rules of civil procedure, the Alabama rules of criminal procedure. Y'all see how misleading this is? These people real slick. They real slick. They merged all 4 of these jurisdictions into one building, so you don't know who you're dealing with. This is why you're trying to ascertain the nature of the action, because different jurisdictions were prosecuted in a different way. And there were different pleas to different jurisdictions. So he's trying to ascertain the nature of it. They're never going to tell you that. Now, I don't know what he would do if this man actually told him that this was admiralty. They're never going to tell you that anyway. I've never had one tell me that. Let me go back to the chat and check, see if anything going on. Let's see. I think people need to bring up this nature and cause issue in the form of a demur. That's one. Well, you can do it like that, SG. You can, or you can demand it. They have to tell you. They have zero discretion to ignore telling you that. They don't have any discretion to tell you that. To be honest with you, they don't really have any discretion because they're administrative officers. Let me see. Lawyers go to law school to learn procedure. That's very true because they really don't know what's going on. These people don't know what's going on. This man don't know what this man he really don't know what he's talking about. A statute designates written so-called law in contradistinction to the unwritten law. Statutes are not laws. If there were no statutes, there would still be law. So how can statutes be laws? Statutes are laws limited to the corporate territorial jurisdiction of the legislature. That's it. And they don't extend outside of the corporate territorial jurisdiction of the legislature. You're dealing with a territorial government. That's what you're dealing with. It ain't no different than what's going on in Washington, D.C., in the District of Columbia. It's the same thing. A political subdivision, like a county, a city, or whatever, those are territories. They're political subdivisions. A political subdivision is a territory. This man don't know what he's talking about, man. Matter of fact, let me pull up something else. Because he's in Kansas right now. So let me see if I can pull this up. Yeah, give me a second. I had it last night. I gotta find it again. I think it's this one. Which one is it? I think it's this one. Right here. Now, this guy's in Kansas, right? This is Kansas. I think this is a Supreme Court case out of Kansas. Yeah, Kansas Supreme Court case. They are recognizing this principle. They are acknowledging this principle exists. All right. Let's go down when they talk about this right here. The right of the citizen to travel upon the highway and transport his property thereon in the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for private gain. In the running of a stagecoach or omnibus, the former, meaning the fundamental God-given right, is the usual and ordinary right of a citizen, a common right, a right common to all, while the latter, the privilege, the tax, is special, unusual, and extraordinary. As to the former, meaning the God-given fundamental right that exists independent of the Constitution and independent of the legislature, as to the former, the extent of legislative power is that of regulation. But as to the latter, meaning the privilege, the tax, its power is broader. It's almost as if it's plenary. The right may be wholly denied, or it may be permitted to some and denied to others, because of its extraordinary nature. This distinction, elementary and fundamental in character, is recognized by all authorities. That means it's recognized by all of the Supreme Courts within this country. They already know this stuff. But you got this idiot, where he at? With 147,000 subscribers preaching this BS, teaching you this BS. This man don't know what he talking about. Y'all need to stop listening to this dude, man. He don't know what he talking about.
Discovery in this case?
I thought in I put a special appearance and affidavit in about a week ago.
Well, there's something that's listed as correspondence in the court file. I'm looking at it now. It's not an official pleading. Neither does it state that you've requested information from the state that we refer to as discovery.
You didn't receive. I emailed. I actually faxed the. I faxed the special appearance. Did you receive it?
Whether they received it or not is irrelevant. You can't make a special appearance because you are not a lawyer. Either you can...
This man don't know what he's talking about. Did y'all hear this? This man don't know what... This man don't know what he's talking about, man. Anybody can make a special appearance. As a matter of fact, he has more authority to make a special appearance than any attorney because their first duty is to the court and not their clients. Let me see if I can pull this up. Right here. Look at all this. This is just all over the country. 1968, 1994. Just different cases all over the country saying the same thing. An attorney owes his first duty to the court. An attorney owes his first duty to the court. He assumed his obligations towards it before he ever had a client. His oath requires him to be absolutely honest, even though his client's interests may seem to require a contrary course, so on and so forth. Let's go down and read this some more. I told y'all this man don't know what he's talking about. 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 Y'all need to stop listening to this dude, man. An attorney owes his first duty to the court. An attorney owes his first duty to the court. All over again. Let's go down. What else is it going to say? An attorney owes his first duty to the court. Oklahoma. An attorney owes his first duty to the court. Nebraska. An attorney owes his first duty to the court. Nebraska, Illinois. One of the primary duties of an attorney is that owed to the court. He is an officer of the court. They're talking about the attorney. And owes to the court a duty to be obedient to its rules and orders. All right, now this man said you can't make a special appearance unless you're a lawyer. That man is lying to you. As a matter of fact, you can make a special appearance after you have voluntarily surrendered to the jurisdiction of the court. Let me show you what I'm talking about. Show you exactly what I'm talking about. All right, so let me give y'all a scenario. So say, there's a lawsuit going on, somebody sued you, and they served you a copy of the summons and the complaint, which as a matter of law, once you're served a copy of the summons and the complaint, the court can exercise in personam jurisdiction over you. Okay, cool. All right, but let's say throughout the process of you litigating this case, the opposing party who sued you, they didn't give you a copy of a motion. All right. And that motion was granted. But they never served you a copy of that motion. They never served you a copy of the motion. So what does that mean in regards to the order that was issued as a result of the motion or the judgment or whatever you want to call it? That means it is void, ladies and gentlemen. Anytime that anybody acts in a manner that is inconsistent with due process, they lose jurisdiction. A judgment rendered without personal jurisdiction violates due process. They have to give you a copy of everything that is being filed in that docket. And if they don't, they violate due process. That means whoever it is that filed a lawsuit against you, they have to serve you a copy of everything. That means the judge, so-called judge. They have to serve you a copy of every order, every decree, every judgment. They have to give it to you. And if they don't, they violate due process. They lose jurisdiction. They have to comply with due process throughout the entire litigation of the lawsuit. not just at a particular point, and no, it don't work like that. They have to give you due process throughout the entire litigation of the case. I don't care if you're in a court of equity, which is issuing decrees. I don't care if you're in a so-called common law court, whatever. They have to give you due process. So anytime they issue an order or anytime a motion is filed and granted in a manner that is inconsistent with due process, then you make a special appearance and you file a Rule 60B motion to vacate the judgment because it is void as a matter of law due to lack of personal service over the defendant. Now it may be a little different in other places, but generally speaking, they're gonna call it a Rule 60B motion. So let me show you what I'm talking about. We are already over there, so let me go to Google. This man don't know what he's talking about, y'all. That man do not know what he's talking about. So Federal Rules of Civil Procedure. You can do this in a civil case or a criminal case. I don't care if this rule is not in a criminal case because this is a principle. All right, I don't care. Rule 60. Let's go up some more. Relief from judgment or order. There it is, Rule 60B4. The judgment is void. This is the Federal Rules of Civil Procedure. Now let me show you the let's just go to a random state. Let's go to Texas. Well, now Texas is a little hard. Their code is a little hard. I don't even like the way that they look. So let's try Florida. Florida might be, well, let's do Georgia. Let's do Georgia. So we're gonna go to Google and we're gonna type in Georgia, Geo, Georgia Rules of Civil Procedure, whatever. Let's see if this is it. All right, civil practice. What are rules of procedure? I think this would be it right here. Oh, so I'm already on the page. I must be already on the page. So let's see. Georgia court rules, Georgia Supreme Court, blah blah blah. What are rules of procedure at? Nah, this ain't it. What is it? I don't know what that is. I'm on the wrong website, y'all. I apologize for that. All right, Uniform Rules of Superior Court, Georgia Court Rules. Let me see if this is it. Preamble Rules, Definitions, Motions, Rule 6. Let's see. It might be right here. Oh, no. Let's go to Motions. Motions in civil cases, hearing, reply, failure, motions in emergencies, summary judgment, motion judgment. This ain't it. Uniform. Let's go to Rules. This is why I don't like doing other people's stuff because you got to go through all this stuff to try to find it. Let's do it like this. Motion to vacate Georgia. I'm trying to show y'all how I do my research. JEO or GIA rules, civil. I probably still spelled Georgia wrong. Procedure. All right, let's see what we get. Matter of fact, I'm gonna do it on Google. Let's go to Google and do it. Google, it should pull up on Google. Relief from judgment. Why do they got this looking like? Alabama stuff just so simple. You got to go through so much stuff. Let me see. Let's see if this is it. There is a newer version on Georgia Code. Let's go here to the newer version. That'll be 2022. All right, collateral attack, civil practice judge. Okay, so this is in chapter 11 in the codes. All right, B, methods of attack. A judgment may be attacked by motion for new trial or motion to set aside judgment, blah, blah, blah. Motion to set aside, lack of jurisdiction over the subject, person or subject matter. So this will be, in Georgia, this will be a rule, not a rule, but a, looks like a section 960 motion. D2. Not, is it 2? Let me see. Yeah, well, 1, lack of jurisdiction over the person or subject matter. It's void. It's a void judgment. That's what this will be, a void judgment. Because anytime they issue an order that is in a manner inconsistent with due process, they violate due process. Let's see. What we got? What we got? One wise lady. She said, I finally got a star. I appreciate all the support, y'all. I really do. By the time you're in court, you've done too much to allow the court to presume you have waived your right to challenge personal jurisdiction. Man, look, you can make a special appearance or a general appearance. You don't even have to be in court. You can just file a motion in there. All right. You can do that. Now some cases, it's not even considered an appearance if you're challenging the jurisdiction because they can't get jurisdiction where they don't have it. I don't care if you filed a motion in there. They don't have jurisdiction. They don't have jurisdiction. And the only thing that they can do is dismiss the case. That's the only thing they can do. Whippersnappers. Everybody is a lawyer under the maxim that ignorance of the law is not an excuse, nor can be used as an excuse. Therefore, we all are lawyers. Some just are more experienced and better lawyers than others. I agree with that, AC. I agree with that. The last time I was detained, I filed a demur and the charge disposed as deceased. Let me see. I filed a demur and the charge disposed as deceased. What? So they disposed of the case as, I mean, what do you mean when you say deceased? The charge was disposed of as dead. Yeah, I'm not sure what you mean. What do you mean, SG? The previous times I filed motions to dismiss that were dismissed for judicial efficiency and ACIS special conditions, local police have been acting weird lately. They get behind me, then take off. I think their automatic tag readers are telling them to keep it moving. It's probably is. I've been stopped by a sheriff. This was a problem. State troopers and 3 to 4 different types of so-called municipal police officers with active warrants, with active capious warrants. One of these men looked me dead in my face and said, "Do you know you have 8 active warrants for the city of blah, blah, blah?" I said, "No." Of course I knew, but I said, "No." He said, "Well, I'm not going to do anything to you, but you need to get this fixed." The city in which I had the so-called capious warrants for was probably like 15 miles away. He could have drove me there. It probably wasn't 15 miles away. It was like maybe 10 miles away. He could have drove me there, but I'm guessing he didn't want to, get sued or something like that. I don't know what it was. But let me go back here. I want to give y'all some game, man. We're gonna go to Alabama. I like doing Alabama, so their stuff is very simple. I can't stand when other states write their codes the way that they do. It gets on my nerves. All they do is frustrates me. I think that's a good case right there too. I might go and read that case. Well, yeah, the older cases are. I'm not gonna read the whole case. I'm just gonna read some of it. The older cases are very good. This is from 1947. It's not that old, but I'm gonna go and read it. All right, shouldn't be that. I might. This one is kind of long. Let me see what it's about a little bit. Responded abuse, distraction, striking a plea and abatement, emotion, blah blah blah. Jurisdiction absolutely essential to and should appear somewhere on the record that the corporation was engaged in business in this state. So if somebody filed a mandamus, let's get to the law of it. I want to get to the law of it. Let's see. A judgment under the conditions here alleged against a non-resident, not properly brought, into court by due service of process and not having waived jurisdiction would be void as inconsistent with the rights guaranteed by the 14th Amendment of the Federal Constitution. Okay. The force of the decisions on this question is that the objection by a non-resident in such cases to the jurisdiction of the court is not a mere technical one, but the assertion of a fundamental constitutional right to be guarded by both the state and federal courts, and that any rule of court or state statute intended to abridge the right are not to be followed by the federal courts. The question being one which concerns the due process clause of the 14th Amendment to the Constitution, blah, blah, blah. There's some more cases on it, but I don't want to get too much off point. I mean, I tell y'all what, if y'all want me to talk about that a little bit longer in regards to due process and service of process and in personam jurisdiction, stuff like that, if y'all want me to talk about it a little longer to explain it to you, let me know, and then I will. If you don't, then I guess I won't. I don't need to. But I kind of think that y'all get an idea of what I'm saying. So y'all just let me know. I'll come back to the chat a little later, and then we'll pick it up if I need to.
Represent yourself, or you can hire an attorney to represent you in court.
There's a document that looks like it is served or before a notary in Oklahoma that reflects what appears to be your signature and says respondent beneficiary of the named defendant of constitutional rights / benefits.
It should
Is
be
that
like
the document you're referring to?
Yeah, I think is it just only one they went through? Because there's like 4 pages, 4 or 5, a few pages that went through, not just one.
There's a one-page document.
There's only one. It's supposed to be more. If I have faxed to more over there, it was supposed to be like 4 pages.
It's one page. Where it begins is at the top. It says the Supreme Court said in U.S. versus Mirsky.
Yeah, I have a copy right here with me. I think you're just referring to the last page, and I sent like 4 pages of them. I think I got it notarized at the end of it, and I think the notary already sent the last page to you, but it was supposed to be 4 more pages to go with that. And that was the special appearance.
All right. Are you entering the plea of guilty, not guilty, or no contest?
I cannot answer a plea at the moment because I'm not sure what I'm going to be tried under. What jurisdiction am I going to be tried under? I do not understand the nature of the cause of action being brought up yesterday.
This is by far the most misunderstood right that sovtards consistently quote. You do not have a right to understand the nature and causes of the criminal charges being brought against you. According to the Sixth Amendment, you have the right to be informed of the nature and causes of the charges being brought against you, not understand, meaning that if you're too stupid to read and understand the statutes that are being used to prosecute you, then you might want to hire a lawyer who does understand.
Man, I don't know what he's talking about, man. This man do not know what he's talking about. You can ask these people this question, and they will never answer it. They're never going to tell you the nature of the action. When they say nature of, we're not talking about the nature of the charge. We're talking about the nature of the jurisdiction. What jurisdiction are you prosecuting this case under? There's 4: common law, equity, maritime, and admiralty. Under which of these jurisdictions are you exercising authority? Because that's all jurisdiction means, authority. That's it. It's not a geographical area. Venue deals with a geographical area. Jurisdiction just means authority. That's it. Under which of these jurisdictions that you're exercising this? Why is that question so hard for them to answer? They never want to answer this question, y'all. But we crazy though. We crazy. We sovereign citizens. We think laws don't apply to us and yada yada. That's not what we're saying. We're saying that these statutes do not lawfully apply to us. That's exactly what we're saying. We're not saying we're free to do whatever we please with impunity, because obviously that's not true. Man, this man here, man. This man don't know what he talking about, man. I don't know how this man get all these. This man do not know what he is talking about. I've read, so I'm not even reading anything, y'all. All of this is off the top of my head because that is literally how many cases that I have read.
I've explained what you're charged with. I'm going to put you down as a plea of not guilty and set this matter for trial.
I'm gonna stop right there. See that was right. What he just did when he entered a plea of not guilty, he just performed a ministerial duty. All right, let me show you what I'm talking about. I'm finna show you. Give me a second. We'll take it out of here. And we're gonna go here. We're gonna go back to Google. Let me show you all this shit, man. These folks here crazy, man. We're gonna go to the Alabama. Rules of let's say criminal procedure right here. Let's go here. Let's go down. Where is it at? Is it 4? Is it 4 arrest without a warrant? Telephone. I think it might be initial appearance where they take your plea at. Preliminary hearing. Which one is it? What they do the pleas at? Summons. Commencement prosecuting criminal procedure. I think it's this one. Let me see. Is it this one? They're gonna tell you what the types of pleas that you can make. I gotta find it. Y'all give me a sec. I gotta find this one. Arrest without a warrant. It must be. I think it's gonna be an arraignment. Is it the arraignment telephone procedure upon arrest? Where is it at? I know it's in here. Release. Is it up here? Commencement of criminal proceedings, prosecution of criminal complaint, duty of judge upon making a complaint, summons. Damn it, where is it at? Right to appointment of counsel, waiver, determination, release, defendant release. Let me see if I can find it on Google because I can't find it on here. I'm gonna spend a little bit of time on this, y'all, because I want y'all to see this. Alabama rules of criminal procedure. Plea guilty. Where's this rule at? Let's go to pleas. Which rule is this? Way down there, number 14. Okay, arraignment and pleas. All right. All right. Failure to plead. This is a subsection D. Failure to plead. If a defendant, when arraigned, fails or refuses to plead, first off, this guy didn't fail to plead, and he didn't refuse to plead. He's trying to ascertain the nature of the jurisdiction. All right. He can't enter I would call it a wise plea. He can't enter a wise plea unless he knows that. A defendant, when arraigned, fails or refuses to, if a defendant, when arraigned, fails or refuses to plead, or if a guilty plea is not accepted, the court shall enter a plea of not guilty and set the case for trial. So let's go down. I'm going to show you where they got that from. What was that? That was D. Let's see where we at. Is this it? Howard versus State. That's where they got it from. Right there. Okay. So this is a Howard versus State. Let's see if Howard versus State is on case text. Probably not, because it's an old case. It's probably not. I don't think it's on here. Howard versus State. All right, it's not on here. Because if it was, it would have showed up. So what is that? That is 65. It's volume 65, Alabama 18. All right. I got so many. I gotta close some of this stuff. I got so many tabs up here. I want to go to Alabama. Right here, we're gonna find this case. This is how I find. I think it was a volume 165. Let me go back and check. I think it was 165, 18. Yeah, 165, page 18. There it is right there. See it? Howard versus State. All right. I don't like the way that one looked. Howard versus State, 165. Right here. All right. Download this PDF file. How long is it? Okay. This is about 12 pages. All right. So we're going to see where they got this from. Let's see. There's no writ, blah, blah, blah. Defendant, jury question is home. They are entering a plea for you. They're performing ministerial duties. Did I pass this? I think it's up there at the top. Refusing any charges. Plea. Crane. Y'all give me a second. It must be up here at the top. Evidence charge, some, blah, blah, blah. PL error, evidence sending to show. Let's see if this will work. Page 10, okay. Here it is right here. Okay. Nothing more than a calling of the hands accused to the bar. Our statutes direct that if a defendant in arraignment. Okay, here it is right here. See where it says our statutes, not no cases, our statutes directs that if the defendant on arraignment refuses or neglected to plead or stands mute, the court must cause the plea of not guilty to be entered for him. So let me read this in another manner for y'all. Our ministerial duties, because this is a statute, they're following statutory procedures. Our ministerial duties directs that if the defendant on arraignment refuses or neglects to plead or stands mute, the court must cause the plea of not guilty to be entered for him. That is an administrative duty that he just performed. He's an executive administrator. Under our practice and statutes, under our practice and administrative duties, one charged of a capital offense is required to be arraigned, and his plea is to be interposed at least one entire day before the trial, before the day of the trial, so that if may be determined that whether or not he is entitled to a special veneer for his trial, blah, blah, blah. If on arraignment he pleads guilty, he is entitled to a special veneer. If he pleads not guilty, he is, and the special veneer together with a copy of the indictment, blah, 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 whatever. But he just performed the ministerial duty. This is why you got to go and read these old cases. Man, these old cases got so many jewels in it. If I had enough time, I would read it. I just don't have enough time, y'all. This case right here telling you how arraignments happen at common law. I think I'm gonna read that section, and that'll probably be it on this case. An arraignment at English common law was much more formal than with us now, so they modified it. Under the former Lord Hale, an arraignment consists of three things. First, the calling of the prisoner at the bar by his name and commanding him to hold up his right hand, which, thought it may seem a trifling circumstance, yet it is of importance, for by upholding his hand, constant de personam indicta. I forgot what that meant because I went and looked it up. And he owes himself, and he owns himself to be of that name. That's very interesting because y'all know we be talking about this all caps name and all that stuff. That's interesting. I forgot about that. Second, reading the indictment distinctively to him in English that he may understand the charge. Third, demanding of him whether he be guilty or not guilty, and if he pleads not guilty, then the clerk joins issue with him called priest and enters the prisoner's plea, then demands how he will be tried. And the common answer is by God and my country. And thereupon the clerk enters the clerk enters, polls say, I'm not even sure what that is, and prays to God to send him a good deliverance. That's very interesting. Yeah, this is why y'all gotta go and read this stuff, man. These folks already know this stuff, man. They already know this stuff, man. Let me see. Practicing law from the bench. Practice. Okay, the court made unstated presumptions based on his actions. He didn't. Dang it, it's gone. It's gone. I was trying to read something, but it's gone now. Practice from the bench. Notice that document refers to a defendant, not an accused. Which document you mean, SG? Which document? He's already participating as a defendant, whether he knows it or not, because he can do is preserve his questions about the nature of the action for appeal, the way things are looking. Well, remember now, anytime they issue an order in a manner that is inconsistent with due process, they lose jurisdiction. You have a right to know the nature and cause of the action. So that means they have to disclose to you the nature of the action. And if they don't, but they go ahead and set a hearing, they lose jurisdiction. So he's right. They don't have any, this is all smoke and mirrors, man. Anytime they do anything to you in a manner that is inconsistent with due process by default and as a matter of law, we're going to say in equity, they lose in personam jurisdiction over you to prosecute you. Anytime they violate due process, they have zero discretion to not inform you of the jurisdiction in which the case is being prosecuted under. I had to speak with the judge's secretary about a body cam request, and they told me district courts are not courts of record where I am. You better have a court reporter if you plan to appeal. Yeah, you better. Even if they are courts of record, they're not authentic courts of records because a court of record traditionally adheres to the jurisdiction of common law. But these are not common law lawsuits. The jurisdiction in which they're operating under is not common law jurisdiction. I did a video on this, man. I wonder if I can find that video. I'm gonna see if I can pull this video up for you, SG, because it's on my YouTube channel. I'm gonna see if I can find it. I got so many links. I gotta delete some of this stuff. Let me delete that. I'll get to that video in a minute. Let's go to my YouTube channel. Get here. Where we at? Videos right here. Y'all gotta pay attention to this stuff, man. I've been dropping jewels in these videos if you pay attention and go and listen to them, man. Is it this one? I think it's these two videos, I think. I believe that's what it is. I wish I had that case. It's on my computer though. Well, it's on my other laptop. It's not on this one. But go watch these videos. Where is that? I just showed them to you. I forgot the links to them already. I think it's inferior courts within superior courts or something like that. Is it this one? Right here. Okay. Go watch these two videos right here. This is part, what is this? Okay, this is part one, and this is part two. Go watch these videos right here. I believe I mentioned it in this video right here. I don't care if they I don't care if they make it a court of record by statute. If they're using a statute, that is prima facie evidence that it is not operating under common law jurisdiction. What they are doing is they are trying to make their administrative agencies look and function just like our courts. Their administrative agencies, they call them inferior courts. They're not courts. They look like courts and they function like courts, but they're not courts. They are administrative agencies. All right. The people created courts in the Constitution. These courts are called superior courts or courts of general jurisdiction. The administrative courts are called inferior courts or courts of limited jurisdiction. General jurisdiction, aka superior courts, they hear all four jurisdictions, meaning common law, equity, maritime, and admiralty. They hear all four of them. Courts of limited jurisdiction, they don't do that because they don't have the authority to do that because of separation of powers. Uh, what's good, Focus? What's good? What's good? Sorry, the deleted comment you started reading. The court has unstated presumptions. The defendant hasn't properly rebutted those presumptions. Yeah, that too. Um, his actions reinforce their presumptions, so they push forward and treating him as the defendant. He technically hasn't asked what the nature of the action is. Ask and you shall receive. He keeps misstatements that he doesn't understand the nature and cause. The court only has to answer a question. Well, they have to make sure that you understand before you go forward. Answer questions with questions. On the other hand, the court issued and summons, and he showed up. He answered to the name. He filed motions, or at least documents into the case. Those are minimum contacts. Maybe. Well, I don't think those are minimum contacts. I think minimum contacts are like a resident address, a driver's license, registering your kids in public school, stuff like that. I could be wrong, SG. I'm not a guru on this, all right? So I could be wrong. I make mistakes. I don't know all of the answers. All right. But did you see that video, excuse me, SG, that I did saying filing motions doesn't grant jurisdiction 100% proof? I'm gonna show it to you. Let's go. It's gonna be down here. Yeah, it's gonna be down here. Where we at? Empty jurisdiction. It must gonna be up some. Right here. This video right here, SG. This is the video right here. Correction, go back to that Latin term you read and said you used to know what it meant. All right. Give me a second, SG. I gotta find that. I hope I didn't delete that case. Did I delete the case? Oh, it's down here. All right. I think it was. Is it this one right here, SG? I think you're talking about this right here. By holding up his right hand, constant de persona indictia, and he owns himself to be of that name. I think that's what you're saying. Is it this one right here, or is it something else? Isn't filing motion asking permission from the court? I would say yes. AC, I would say yes. Essentially, yeah, but I mean, you don't want to. They don't play fair, man. So just now, you can demand relief. You know, you can respectfully demand that the case be dismissed or whatever. But I mean, if they want to deny it, they gonna deny it, man. They do this to their own colleagues, man. They do this all the time to their own colleagues. I think they do it to us more than they do it to their own colleagues, though. That's just my personal opinion on it. Let me get back to this video, y'all.
If you wish to,
because I was my special appearance didn't make it. I was like, I need to resend that as well. How can I reset it? So I gotta have a chance to resend my special appearance because it didn't make it in. I guess you only had the last copy of it. There's more pages that you didn't see. I need to enter that in beforehand. How can I reset it so I can do that? I have time to do that. I can do it today, and we can reset it for the same time next week if that's okay with you.
I'm going to go ahead and set this for trial, and you can, if you have pretrial motions that you would like to address, they need to be properly filed.
Okay.
Sometimes.
See how this man did not ask the question in regards to when this man was asking about the nature, in other words, about the jurisdiction in which the case is being prosecuted under. They have zero discretion to ignore that, y'all. And when they ignore that, they are issuing an order in a manner that is inconsistent with due process. And when they do that, they lose jurisdiction. Right off the bat, they lose jurisdiction. The reason why they ignore that, man, is because they're not going to, they don't want people to know what's going on in these administrative courts, man. So-called courts, anyway. They don't want y'all to know.
If people are representing themselves, they're still held to the same standard as an attorney would be.
Yes, sir.
And sometimes people don't have the experience to do that, correct attorney, but I'm going to set aside 2 hours for bench trial.
I'd like to be tried by jury if that's okay. If I'm going to be separate trial, if it has to be separate trial. Like
have you made a written request for trial by jury?
I have not. This is my first appearance today.
If you're seeking to have a jury trial, then you're going to need to file a written motion in that regard.
Okay.
Again, pursuant to Kansas law, there are restrictions in that regard. When we set a jury trial, I generally have a pretrial date that we have. You will be required to be here at Elk County to conduct that hearing. If you have pretrial motions that you're wishing to have heard, we typically would do that in advance at a pretrial. I'm going to set a pretrial date at this time. That'll give you an opportunity to place your written motion for request for jury trial. We will set that hearing for, Sarah, can you give us a date within 30 days?
How long would you like for the pretrial, sir?
Anytime is fine before the
That's cute, but I don't think she was talking to you.
the 17th.
Hour.
1 hour. Okay.
Ms. Gillette, on the 17th, do you have very much scheduled with Satterfield for your half day?
Can I do another day besides the 17th? I can't make that day. I have something on that day. Is there like maybe like the 15th or maybe after the 17th? That's the one day I cannot make.
We could do the morning of May 1st at 9 a.m.
So May 1st, 9 a.m., a jury trial, which also means that we probably won't get to see it on YouTube.
No, God! No, God, please, no! 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 No!
Now, with that being said, I'd like to make a special appearance and say thank you to Old Squishy Gardner for not just finding this gem, but for also helping me expose these asshats for their social degeneracy. So why don't you do yourself a favor and head over to his channel to not just watch the entire video without my commentary, but to also subscribe. And be
Anyway, I ain't gonna comment on that no more. But you know, this man was talking about the right to travel and all that stuff. All right, look, I'm only gonna read this case for his subscribers because I know there are some people that are subscribed to his channel that are probably gonna see this video and they gonna come on and they gonna probably gonna make fun of me. Well, I don't care because I read. All right, I read a lot. So what I'm gonna do is I'm gonna read this excerpt from Ex parte Dickey. I'm gonna start right here, all the way down to. I should have highlighted this too. Let me highlight that. All the way down to. I ain't gonna read all that. Where are we at? Give me a second. All the way down to. Where am I at? Right here. Well, no, right here. I'm gonna stop at section 229. All right. This is Ex parte Dickey. And to all of the people who subscribe to his channel, if y'all want to go and read this case, which I advise you to do, this is a West Virginia Supreme Court case, if I'm not mistaken. You can find this on volume 76 on page 576. This is a principle in this case, meaning that this is recognized all over the country, and it also means that your legislatures, your state legislatures, and your county, city, they're all committing treason because they are taxing your right. That right to use the streets as private property, and they are saying you need a license for that when you don't need one for it. All right. So tired of this. As regards legislative power or control, the business or interest regulated by the ordinance is clearly distinguishable from vocations, the pursuit of which does not involve the use of public property. The right of a citizen to pursue any of the ordinary vocations on his own property and with his own means can neither be denied nor unduly abridged by the legislature. For the preservation of such right is the principle and purpose of the Constitution itself. In such cases, the limit of legislative power is regulation, and that power must be cautiously and sparingly exercised, unless the business is of such character as places it within the category of social and economic evils, such as gaming, the liquor traffic, and numerous others. To this list, may be added such useful occupations as may, under certain circumstances, become public or private, under certain circumstances become public or private nuances, because offensive or dangerous to the health. All of these fall within the broad power of prohibition or suppression, some wholly and absolutely, while others conditionally. Such pursuits as agriculture, merchandising, manufacturing, and the industrial trades cannot be dealt with at will by the legislature. As to them, the power of regulation is comparatively slight when they are conducted and carried on upon private property and with private means. It's private property and it's private means. But when a citizen claims a private right in public property, you can't do that. Just like they can't claim a public right in private property, such as a street or park. A different situation is presented. Such such properties are devoted primarily to general and public, not special or private uses, and they fall within almost plenary legislative power and control. This is a right. This right exists independent of that plenary control. It is not dependent on that plenary control. This right is not dependent on the Constitution. In them, all citizens have the usual and ordinary rights in an equal degree and to an equal extent. In the regulation thereof, the legislature cannot discriminate, but as regards unusual and extraordinary rights respecting public properties, its power of control and regulation is much more extensive. Such rights are in the nature of concessions by the public. Wherefore the legislature may give or withhold them at pleasure, because it's a privilege, because they can tax you for it. It may give them for some purposes and withhold them for others, and in the case of those given, it may, upon consideration of character, quality, and circumstances, discriminate, permitting some things of a general class or nature to be done, and refusing to permit others of the same general class to be done, or extending the privilege to some persons and denying it to others because of differences of the character or capacity. The right of the citizen to travel upon the highway and transport his property thereon in the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for private gain in the running of a stagecoach or omnibus, which is what they were doing in this case. You can't do that. The former is the usual and ordinary right of a citizen, a common right, a right common to all, a fundamental right, a God-given right, a right that pre-exists the Constitution itself. While the latter, being the privilege in which that is being subject to the taxation, while the latter is special, unusual, and extraordinary, as to the former, meaning the fundamental right, the extent of legislative power is that of regulation. But as to the latter, its power is broader. The right may be wholly denied, or it may be permitted to some and denied to others because of its extraordinary nature. This distinction, elementary and fundamental in character, is recognized by all authorities. A distinction must be made between the general use, which all of the public are permitted to make of the streets for ordinary purposes, and the special and peculiar use, which is made by classes of persons in the pursuit of their occupation or business, such as hackmen, drivers, driver of express wagons, omnibuses, and etc. And there it is right there. I'm going to stop right here. The rule must be considered settled that no person can acquire the right to make a special or exceptional use of the public highway, not common to all citizens of the state, except by grant from the sovereign power. Blah, blah, blah. That'll be it on that. Now let me go and read this case. Give me a second. I gotta go and do something right quick. I'll be right back. Let me delete this. Delete this right quick. Where is it at? What am I doing? I don't know what I'm doing. All right. All right, we can delete that one too. Give me a second, y'all. I'll be right back. All right. Let's get here. All right. I'm not going to, well, I did say I was going to read this whole case. So I'm going to read. Let me get me some water, y'all. I drunk all my water. All right, y'all. Sorry about that. Okay. Appellate Appellants, being numerous taxpayers of the city of Paducah, allege in their petition that they each own a vehicle exclusively employed for their own private and family use and accommodation and not for hire. I'm going to stop right there. This is another case. This is out of Chicago. This is a Chicago Supreme Court case. The appellees, 373 in number, residents and taxpayers of the city of Chicago, suing in behalf of themselves and all others similarly situated, file a bill to enjoin the city from enforcing an ordinance providing that all vehicles used upon the streets of the city, including those for private use for pleasure, should pay an annual license fee, and that any person using any vehicle without first having obtained a license, therefore, or failing to have said license properly tagged so that it would appear the license had been paid, should upon conviction be fined a sum of not less than blah blah. See how identical these cases are. This is the Illinois Supreme Court case sitting in equity. This is Kentucky Supreme Court case sitting in equity. Let me make sure they sit. Are they sitting in equity? I gotta make sure. I gotta check. If they're trying to get an injunction, they're sitting in equity. But I have to go and see. But anyway, they further allege that by an ordinance of the city council, they have been required to pay an additional. No, that ain't it. I gotta get down to the other part. Where we at? They talking about the taxes, and we're not getting into that. Is this the? Is this the? Oh no, this ain't the case. It's another case. Wait, damn. I'm reading the wrong case, y'all. I gotta find that case. Where was that case at? What was it? Was it Kansas? I don't know if it was Kansas, Alabama. That ain't it. Explain bumpy modes of travel. I think it might have been Kansas. This is the wrong case. But they do discuss that in there a little bit too. But I think that's the wrong case. I think it's Kansas. I think it's 109 Kansas. Is this it? No, I just read that one. That's with the Dickey principle. No, that ain't it. All right. Where was this, man? I don't know where it was. I gotta find it. It's on here though. I'm gonna find it. Cummings, City of Saint. This is it right here. This is the case right here. All right, this one's 4 pages right here. All right. Okay. Let me give y'all that case citation, by the way. All right, this is out of this is out of Missouri. This is out of Missouri, y'all. All right. This case was submitted to the court below on an agreed statement of facts, and judgment was rendered for the defendants. The action was for violation of an ordinance entitled an ordinance, a mandatory of ordinance, blah, 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 concerning public and private vehicles and authorizing the appointment of 2 additional vehicle inspectors. The first section of this ordinance provides that all vehicles, public or private, using the streets of the city for trade or traffic or for any other purpose, no matter whether the owner or owners reside in the city or out of it, shall be subject to the rate of a license tax mentioned in the ordinance. The second section declares that no vehicles of any kind are exempted from the payment of the tax or license named in ordinance, except those bringing produce produced by the vendor to the different markets for sale. Let's see. Ordinance 6596 passed July 3rd, 1868, of which the foregoing is a mandatory. In its first section fixes the amount of the license tax to be levied on each vehicle, public or private. You can't tax private property that's not being used for a public service. You can't do that. But that's what they're doing. They're saying we're using our vehicles for a public service, our automobiles for a public service. That's what they're doing. They taxing the occupation. Like we performing government services, public services. Anyway, and in the third section provision is made that the owners of such vehicles, having paid the annual license tax, shall be released from all other taxes on the same to the city of St. Louis during the period for which the said tax is paid. It is agreed between the parties that the defendant, Whelan, was, on and after the 19th day of April 1870, the owner of 4 two-horse wagons, which were then used on the streets of the city for the purpose of conveying and transporting beer and soda sold by Whelan to the persons having purchased the same from his brewery and factory to the places of business and saloons of such purchasers, that such vehicles were used on the streets of the city in the manner and for the purposes aforesaid. That the vehicle inspector notify. I want y'all to notice how they keep calling his horse and carriage a vehicle. They're saying it's a vehicle. That's a presumption. That's not a vehicle. You got to file an objection. Objection assumes facts, not an evidence. That clearly lacks any foundational, any factual foundation. No witness has come forth to testify if my 4-horse wagon is a vehicle, but they're calling it a vehicle. Anyway, that such vehicles were used on the streets of the city in the manner and for the purposes aforesaid. That the vehicle inspector notified Whelan to take out a license, which he refused to do. That Whelan is one of a firm of brewers. I can't even get the name right, of brewers, and soda water manufacturers who manufacture beer and soda water, and that said wagons are used exclusively in carrying beer and soda water manufactured by them to the different parts of the city where it is sold and offered for sale. That these wagons have been assessed by the city against Wheeling for the year of 1870. That this assessment is a lien for the amount of the tax on the property. And finally, that the wagons in question are not used for any other purpose than that above stated. Such are the facts agreed upon. The violation of the ordinance is palpable. What is this? Palpable, palpable. I forgot how you say it. And the only question is, had the city council, under the charter, authority to pass a law compelling Wheeling to take out a license for vehicles used by him for the exclusive purpose mentioned in the agreed case? Is it lawful for them to do that? Do they have a right to tax him to do that? Let me go and check the chat. All right, let's get back to the case. The provision of the charter under which the power is sought to be maintained declares that the mayor and city council shall have power by ordinance to license, tax, and regulate horses, railroads, the hackney carriages, omnibuses, carts, drays, and other vehicles, and fix the rates to be charged for the carriage of persons and the wagonage, cartage, and drayage of property. It will be observed that the ordinance refers to and requires license to be taken out on all vehicles, public or private, no matter for what purpose. They can't do that. They are used, no matter for what purpose. These folks tried to do what they are doing today over 100 years ago, and they told them they couldn't do it. And so they came back and they changed the legal definition for driver to trick you, and now they're getting away with it because that's exactly what they did. They modified it, but it still means the same thing as it did 100 years ago, 200 years ago. It don't matter. And that's what they're gonna hold in this case. They tell you they're going to implicitly tell you that it doesn't matter by the way that they're going to rule in this case. Read this again. It will be observed that the ordinance refers to and requires license to be taken out on all vehicles, public or private, no matter for what purpose they are used and whether they are public or private. According to the literal interpretation of this law, every person who may keep a vehicle for his private use must obtain the license or else be liable to the penalties imposed. This ordinance is certainly extraordinary in its character and must be strictly construed, meaning strict scrutiny. What was the obvious extent of the legislature in the passing of the enactment? Was such an exercise of power as this contemplated? The clause must be taken as a whole to show its purpose, objective, and scope. It is to license, tax, and regulate horse, railroads, hackney carriages, omnibuses, carts, drays, and other vehicles, and fix the rate to be charged for the carriage of persons and the wagonage, cartage, drayage, and drayage of property. The whole context of this grant of power shows that it was intended to apply to a class who transact business for the public. Did y'all see that? You're transacting business for the public. You're providing a government service. And that service belongs to the public. Y'all think I'm lying, don't it? Let me show y'all something. Let me show you something. Gotta show y'all something, man. I probably did I delete it? No, that ain't it. Iowa Federal. I probably deleted it. There was a bunch of them. I got so many documents up here, man. It's gonna be on here. It's gonna be right here. It's gonna be down a little bit more. Where is it at? I know it's in here. Is it fundamental? Oh, not that one. It's gonna be in here. I'm sorry. It's gonna be in here. I'm tripping. Right here. Oh, I still have it up here. Okay, it's up here. I thought I deleted it. Where is it at? Right here. This is what I gotta go and read this some more. The demur raises the question of the context of the right of one who has undertaken a public business to make contracts which tends to infringe the public rights. Those who engage in such business thereby surrender certain rights which belong to private persons. The common carrier is not permitted to carry A and refuse to carry for B under like circumstances. The innkeeper must, to the extent of his accommodations, entertain all who apply in a proper way by virtue of their employment. They have impliedly agreed to do these things. Why did they impliedly agree to do these things? Why? I mean, what's the consequence of that? The consequence is their services are public property. So if you want to perform a public service, that public service is public property. This is how they tricking people. Man, these folks slick, y'all. These folks so slick. The whole context of this grant of power shows that it was intended to apply to a class who transact business for the public. Is this making sense for y'all, man? Does that make sense to y'all? The whole context. Let me go back up. I got to go back up, y'all. I got to, because I got to make this make sense for y'all, man. Let me check the chat. All right, let's get back to it. This ordinance is certainly extraordinary in its character and must be strictly construed. Why must it be strictly construed? Because you're dealing with fundamental rights. And when anytime the government starts to infringe on a fundamental right, they have to prove that they have a compelling public interest to do so. And when they do, they have to strictly construe this statute or ordinance. And that's what they're going to do right here. They're going to substantiate it for you. They're going to tell you its true meaning and its true scope and where it starts and where it stops. In other words, where it's applicable and not where it's applicable. That's what they're going to do. What was the obvious intent of the legislature in passing the enactment? Was such an exercise of power as this contemplated? The clause must be taken as a whole to show its purpose, object, and scope, the limit, where it stops at. It is to license, tax, and regulate horse railroads, hackney carriages, omnibuses, carts, drays, and other vehicles, and fix the rate to be charged for the carriage of persons and the wagonage, cartage, and drayage of property. The whole context of this grant of power shows that it was intended to apply to a class who transact business for the public. Why? Because those are public services. And when you do that, it's property of the public. So you limit some of your private rights. which is why he didn't get this license, because he didn't have to. They just told y'all they don't care what this ordinance says. All right. It really means this, even though it says this. That's what they saying, y'all. That's exactly what they saying. Let me go back and check this chat. Y'all got these folks real tricky, man. These folks so slick, and they do this all the time, y'all. All the time. Let's see. While they're saying it, and the derivatives, they use the legal name or Mr. Mrs. is when they deceive you into contracting. Yeah, that's probably one way. Let's get back to this case. The whole context of this grant of power shows that it was intended to apply to a class who transact business for the public and hold themselves out to the community as seeking general employment. That means they're seeking employment from everybody who's willing to contract their services. Viewed in that light as a police regulation, it is viewed in that light as a police regulation, it is of admitted utility and convenience and promotes uniformity and prevents extortion. But that consideration has no influence as respects private vehicles, which are used by their owners purely for private purposes. These are subjected to a general tax as any other personal property. I am satisfied from the general wording of the statute that the legislature has never intended that the power should extend to vehicles used by persons for their own convenience or in the transaction of their private business and not engaged in any public employment for which compensation is received. These folks slick, man. They real slick. You gotta watch these folks, man. What they'll do is when they pass so-called legislation or enact ordinances or whatever, and these ordinances are held unconstitutional or whatever, they'll read the case and then they'll try to find loopholes in it, and then they'll come back and then try to reword the ordinance. They're trying to trick you, man. They'll reword the definition within the ordinance. But they can do that. That's just like with the term driver, how they changed the definition of driver. It doesn't matter if they change the definition of driver. It's irrelevant because even if they change it, it still doesn't mean exactly what they're saying. They're gonna substantiate that definition for you. That's what they're gonna do, and that's exactly what they did in this case. Appreciate that, SG. I really appreciate that. That's exactly what they did in this case. Let me see if I can find. I think I got another one on here too. I want to read for y'all. Let me see if I can find it. Let's go down. Is that it? Nope. I'm trying to find another one right now, y'all. Stack versus what is? I don't know what that one is. Oh, bus lines, ex parte Dickey. Give me a second, y'all. I'm just trying to find. Is that no? Did I read that case? I think I read this case. Let me see. I'm not really sure. Uh, no, it's not this one. It's another case. Trying to find it. I think I just read this one. Okay, no, I didn't read this one. Here's another one out of where this is out of Chicago, not Chicago, but Illinois. All right, this one's 4 pages. Let's see. All right, yeah, this is another case. I don't know how many times I got to do this to show people that these folks are lying to you, man, because that's exactly what they're doing. All right. Uh, this was a prosecution for an alleged violation of an ordinance of the city of East St. Louis. The ordinance is as follows. No person, company or corporation shall, without complying with the provisions of this ordinance, use or cause to be used any wagon, dray, cart, or other vehicle of burden to convey loads within the city or on the streets of this city, or hire out, or keep for hire, or use, or cause to be used for hire in the transportation of persons or property from one part of the city to another, or from places within to places without the city, or from places without to places within the city. Any hackney carriage, omnibus, baggage, baggage wagon, buggy, dray, cart, wagon, or other vehicle. The following provisions require the owner or owners of the vehicles mentioned above to take out a license fixing the rates. The authority claimed for the passage of the ordinance is under the provision of the city charter giving power. Let's see, to license, tax, and regulate and control wagons and other vehicles conveying loads in the city, to prescribe the width and tire of the same, the weight of the loads to be carried, and the rates of the carriage. The admitted facts were that the defendant kept a family grocery store in the city and had used a one-horse spring wagon without having a license. Therefore, in delivering goods sold by retail to his customers, and in bringing loads of goods from St. Louis, Missouri, where he purchased stock for retail at his store, that he never used the wagon for hire or otherwise. Then in the prosecution of his business as a grocery merchant. The question made is whether the defendant was required under the ordinance and provision of the charter to take out a license. The charter authority is to license vehicles conveying loads and prescribe the rates of the carriage. Again, I want y'all to pay attention because they're trying to call his horse-drawn carriage a vehicle. Because the term vehicle is commercial in nature. This making sense for y'all? Because this show makes sense to me. Let me check the chat. I appreciate the donations, SG. I really appreciate that, man. I don't think nobody has ever donated to me while I was live. I don't think nobody has ever done that. And I really appreciate that, man. Thank you. Let's get back to the case. To license and to prescribe the rates of a carriage alike apply to the vehicle's name. So it is only such vehicles which are in contemplation as the subjects of license, in respect to which the rates of carriage are to be prescribed. It cannot be supposed that it was the intent to fix rates of carrying in respect of such vehicles as sold only be used by persons in the prosecution of their ordinary private business. Any provision of that sort is unknown in our legislation, and the enactment or authorizing of such a provision cannot be imputed to the legislature unless the intention to that effect is expressed in clear and unmistakable terms. It is otherwise as to another class of vehicles, those used in the exercise of the employment of carrying for hire. In respect to such vehicles as those used for hire by hackmen, draymen, and the like, it is customary within municipal authorities to regulate and fix the rates of carriage. It is an ordinary police regulation to protect the public against extortion and imposition on part of those engaged in the business of common carriers for hire. Give me a second, y'all. I'll be right back. One using a vehicle not for hire, but only in the course of his ordinary private business does not come within the reason or necessity of any such municipal regulation. One using a vehicle not for hire, but only in the course of his ordinary private business does not come within the reason or necessity of any such municipal regulation. The provision of the charter as to prescribing the rates of carriage can reasonably apply only to such vehicles as used for hire. What? They tried to do this over 100 years ago, y'all. This is how they got away with it, though. They took out for hire out of the statutes. They took it out of the statutes. But it doesn't matter if it's in the statutes or the ordinance or not. It's irrelevant. I just showed y'all a case that just said it's essentially it's irrelevant. It doesn't matter. Under the rule of strict construction, which is I just said, strict scrutiny, not too long ago, which must be applied in such a case, we are of opinion that the authority here to license is qualified by the clause for prescribing the rates of carriage, and that the true construction, or in other words, the actual or the scope of the charter provision is that it does not authorize the licensing of all vehicles conveying loads in the city. What? But such only of them in respect to which it is proper and customary within municipal authorities to prescribe the rates of carriage, viz., those used for hire by common carriers in the city for hire. A somewhat analogous provision in the charter and an ordinance of the city of Chicago came under consideration in the case of Farwell et al. Versus City of Chicago, where it was held not only to the case of wagons used by the defendants in the regular course of their business as wholesale merchants, but that it only extended to the wagons of common carriers for hire. How many times I got to do this, y'all? You're not crazy. All right. You're not crazy. You're not crazy. So let's see what they ruled. So essentially they held, holding that appellant did not, by the acts complained of and admitted, incur any penalty claim for not taking out a license for his wagon, the judgment of the court below must be reversed. But we crazy, y'all. We crazy. We crazy. Let me give y'all this case citation. Was it page 156? This is the Illinois Supreme Court case from 1875, volume 77, on page 156. This is a principle, y'all. But we crazy, y'all. We sovereign citizens. We crazy. We crazy, though. You know what I'm saying? Boy, these folks get on my nerves, man. Excuse me, I had to get me some water, y'all. I had to get some water. And how much produce you're talking about too, I guess. Maybe that will come into play. Maybe. Maybe. But let me I don't think you were I don't think you were on here last night, SG. So I'm gonna read some of this case too. I'm not gonna read the whole thing though. But I'm gonna give you the case citation. It's on Illinois Supreme Court. It's volume 175, and it's gonna be on page 445. And I think it's City of Chicago versus Collins, I think. Right, yeah, right here. 175 Illinois 445, decided in 1998. Over 100 years ago, y'all, and they told them, no, you can't do that. And what do, y'all? They come right back and they find a way to hide the true definition and start taxing you. That's what they did. Let me go down here. There's something very important in this case that I want to point out. All right. Back to pedestrians, ownership. No, that ain't it. It's gonna go down a little bit more. Right here. I'm gonna start right here. It starts on page, looks like page 456 in this book. All right, but on the PDF file, it's page 12. All right. Any usual method of travel along the streets and alleys of a city cannot be declared a nuisance. The city council may regulate the use of the streets and alleys to the extent that it may require sidewalks exclusively reserved for use by pedestrians and exclude certain character of loads and regulate the width of tires on vehicles used on certain character of pavements and provide that the rate of speed shall be less on certain streets than on others, and otherwise regulate the use of the streets, having in view solely the welfare and safety of the public. The city may also regulate certain occupations. Pay attention, y'all. The city may also regulate certain occupations such as hackmen, draymen, expressmen, and the like. For such regulation is of police character, having reference to the general welfare as a means of preventing improper exactions and extortions. And for the same, a license may be exacted for vehicles used in the transportation of goods and merchandise, or of passengers, or for other purposes of traffic. But such license is an occupation license and not one for use of the streets. Is this making sense for y'all? So why do you have a driver's license? The reason you have a driver's license is it's in the nature of an occupation license because they can't issue you, or in other words, they can't tax you to use the public streets. They can't do that because the use of the public streets is a right, and they can't require you to have a license to use the streets. They're saying you are a driver, and because you are a driver, you're offering a public service, and you need a license. That's what they saying, y'all. Why do you think that they have public property on private property? Meaning, why do you think they have state plates, which is public property, on your automobile, which is private property? I gotta read this again, y'all. I gotta read this again, man. Let me go check the chat. Uh, Let's see. Driver is a commercial term. True. Yeah, driver is a commercial term. It really is. Yes, it is. Yes, it is. But let me show you something though, because I don't know if y'all saw this video last night. I did a video last night, and I just randomly searched the motor vehicle code for 4 different states, and all of them substantially had the same legal definition for driver, which is this definition right here. I'm going to show you right now. I'll get back to that. Let's go here. Alabama Motor Vehicle Code. Right here. General provisions. This is the definition that they had for driver. All right. Every individual who drives or is in actual physical control of a vehicle. You see how misleading that is? That is extremely misleading, because the average man or woman who does not study law, they're going to think, unbeknownst to them, that they are actually a driver. And that is not what they are, because that is not what a driver is. Let me show you what a driver is. I did this last night. I got to do this, y'all. I'm tired of talking about it, but I have to do this. I just got to do it. I got to do it. All right, this is a law dictionary from 1891. This is a Black's Law Dictionary from 1891. All right, we'll close that out. And we're going to go to the section, the D section, the letter D section. This is what a driver is. All right, I don't care about this other definition right here. They can modify it all they want and try to hide it and conceal it all they want. Doesn't matter, because vehicle is a commercial term, and this drive is a variation of the word driver. I don't care about none of that, because this definition, right, a driver still means today, right now, this definition right here, which is one employed in conducting a coach, carriage, wagon, or other vehicle with horses, mules, or other animals. Let me show y'all this other definition. Show you this other definition. This right here. One employed in conducting a coach, carriage, wagon, or other vehicle with horses, mules, or other animals, or a bicycle, or tricycle, or motor car, though not a street railroad car, or whatever. All right, so if you're using a bicycle for commercial purposes, guess what it is? A vehicle. If you're using a tricycle for commercial purposes, guess what it is? A vehicle. If you're using a horse and carriage for commercial purposes, guess what it is? A vehicle. And guess what you are? A driver. See how they hiding this stuff, man? They slick, y'all. But we crazy, though. We crazy. I'm crazy. These people full of it, man. They full of it. They full of it, man. Where's that case at? Let me go check the chat again. They really do. They really, really do talk in circles. Word salad. She called it word salad. Yeah, that's right. That's what they do. It's exactly what they do. All right, let me get back to this case. When I saw this, I was just like, wow, y'all, because I didn't even know this. I thought that they were trying to license you to use the public highways. The city may also regulate certain occupations, such as a hackman, drayman, expressman, and the like for such regulation is of a police character, having reference to the general welfare as a means of preventing improper exactions and extortions. And for the same reasons, a license may be exacted for vehicles used in transportation of goods and merchandise, or of passengers, or for other purposes of traffic, which is commercial term. But such license is an occupation license. That means your driver's license is an occupation license and not for one for use of the streets. That's what that means. The license in the latter name case is designed to operate upon those who hold themselves out as common carriers to the public, and a license may be exacted from such a proper exercise of police power. But no reason, but no reason, but no reason, but no reason, but no reason exists why it should be applied to the owners of private vehicles used for their individual use exclusively in their own business or for their own pleasure as a means of locomotion. Do y'all see that, man? Do y'all see that? Or am I reading that wrong? Am I interpreting that wrong? Am I coming up to a reasonable conclusion that is erroneously being concluded? Let me know. Let me know. What y'all think? Am I reading that wrong? Am I reading that wrong, y'all? Let me know if I'm reading that wrong. Because I'm of the opinion that I'm reading that right. I am of the opinion that I'm reading that right. Anything which cannot be enjoyed without legal authority would be a mere privilege, which is generally evidenced by a license. The use of the public streets of a city is not a privilege, but a right. That means right now, y'all, without a driver's license, without a license plate, you can get into your car and go wherever you want, just so long as you're not using it as a place of business. That's exactly what that means. Man, and y'all think these people don't know this stuff? They know this stuff. Did y'all get all the case citations that I read in regards to the right to travel and stuff like that? I want to make sure y'all got these cases. I appreciate that, Isaac. I really do. Thank you, man. I just want to make sure that I'm not misunderstanding something. Or I'm not misconstruing something because I do make mistakes from time to time. I do. We all do. But I just want to make sure that I ain't crazy, that I read what I just read, and that's what it meant, because that's what it meant to me. Did y'all get that? Do y'all want me to put the case citation in the chat? Or did y'all get the case citation? Which is a principle, by the way. I don't care if this is an Illinois Supreme Court case. This is a principle. It's a principle. Y'all got the cases? I done been on here a little too longer than I expected. I want to make sure y'all got the cases. Let me close this. I can close ex parte dic. Well, yeah, let me save it. All right. What is this? This is the second time somebody has ever donated to me since I've been live. Thank you, Isaac. I really appreciate that. I really do. Really appreciate that. Did y'all get the cases? I want to I don't know what I got to do, but I'm going to make as many videos as I have to in regards to these cases that I just read today to show people this stuff, because these people are knowingly committing treason. And when you bring this up, they want to defame you and make fun of you and call you a sovereign citizen. That's what they want to do. Call you the audacity of these people, man. Did you what? I think you saw the case from last night. I think you were on here last night, Focus. I'm not really sure. Let me see. All right, let me give y'all that case citation. The case that I just read is this case right here. Right here. 175 Illinois 445. All right, now the cases, there's more cases that I read too. Right here. These cases right here, when he says the license in the latter case is designated to operate on the public highway, blah, blah, blah. He gets all of these authorities, he get all of these reasonable conclusions that the so-called judge or the chancellor in this particular case came up with. He got them from these cases right here. I want y'all to pay attention now, because these cases right here, all of these cases are not Illinois Supreme Court cases. This is one from Missouri. This is one from Kentucky. And I'm not really sure which one this is from. It says City of Covington. So Covington versus, I think I have that case. Let me see if I have that case. City of Covington versus Woods. Let me see what that's at. Right here, I do have that case. That's a Kentucky case. All right. 98, Kentucky, 344. Did I do a video on this case? It's 5 pages. I don't think I did one on this one. But I'm going to show y'all the conclusion from this case, though. We conclude, let me make sure I make it bigger. I want y'all to know this is a principle, man. They hiding this stuff, y'all. We conclude that the ordinance, insofar as it imposes license fees on vehicles used or let for hire, is valid. Insofar as it attempts to impose license fees on vehicles not used or let for hire, it is invalid. This is the case right here. Kentucky case. Let me give y'all that case again. Because these people really think we crazy, y'all. Well, some of these people do. This is the case right here. Volume 98. It's a Kentucky Supreme Court case, Volume 98, Kentucky. You can find it on page 344. But we crazy. We don't know what we talking about. We don't know what we talking about, y'all. Let these people tell it. Y'all make sure y'all hit that like button for me. I really appreciate it. We don't know what we talking about. E is a Latin word meaning out of. Oh, that's very interesting. Duco has many meanings, including to draw, lead, or influence. Ate as a verb suffix means cause, to become, or be modified. Usually you hear to bring out of you. Interesting. We assume that means to draw out the best of us, but what it means, but what if it means something is being influenced from us that we actually need to keep in us, like free thinking? Oh, wow. Wow. That's, dang, SG, boy, you cold, SG. You cold. Yeah, you cold. Man, that's, damn, SG, boy, you cold for that one. You want to be a philosopher or something, man. Wow, I didn't know about educate. Thank you so much for sharing. That's cold. All right, did y'all have all the cases? I'm gonna go ahead and get off here. I've been on here a little over 2 hours. Before I leave, though, I want to make sure that y'all have all the cases that I read today. And I also want to make sure that people who watch this video who are not subscribers of my channel, please stop listening to that guy, Team Skeptic, because that man don't know what the hell he talking about. He don't know what he talking about. Private school. Oh, you attend private school, SG? That's dope. That's dope. Uh, but grew up broke. I feel you on that, SG. I feel you on that. I did too, used to get welfare, food stamps, all that stuff when I was growing up, mostly Jewish kids there. Oh, that's very interesting. That's very interesting. Yep. We used to get welfare. Well, I used to, when I was younger, living with my mother, used to get welfare, food stamps. Used to be so poor we had to wake up early in the morning to take the light meter out. So the light man would come get it. Because we couldn't afford to pay the light bill. I done been there before, man. But right now I live by myself. So it's just me. Public answers in public school. Do you know about the Estonian Deception YouTube channel, Rumley and Rowan? Before I go, y'all, I need to make sure that y'all got the cases. I want to make sure I give y'all these cases. And I also thank y'all so much for making these donations. Thank you for becoming a member of my juror members or whatever. It's only $1. I really appreciate that, y'all, because it took me about 3 to maybe 4 days to find these cases. But it was taking a long time because I was spending a lot of time throughout the day trying to find these cases because I knew that we're not crazy. I know we're not crazy. But I think so far I'm the only one that has actually found the case that actually holds this. I think I'm the only one. And I would really appreciate it if y'all did me the favor to make sure that you tell everybody who has ears to listen and is willing to listen and eyes to see and is willing to read to just give them this case. Give them all these cases or show them this video, whatever you got to do. Because this is crazy, man. This is crazy. Is it raining? It is raining outside. I was going to go and do something today. I ain't doing nothing today. What y'all doing? I might come back and do another live. We can probably do a Q&A. Probably come back and do a Q&A later today. There's something that I do want to do. I think it'll be very educational and informational for people. What was it? Is there anybody that has a Fourth Amendment 42 Section 1983 case? Because I want to do it, like I want you to call in. I'm gonna get a call in number. I want you to call in, and what I'm going to do is we're going to draft it live on the air. The ultimate fact section of it, not the other part, but the ultimate fact section and the cause of action section. We're gonna draft it live on the air to show you and other people, to show everybody how it goes. That's how I do my work, how I draft my pleadings. I think that'll be very beneficial for us. We're gonna draft the ultimate fact section of it. You most definitely dropped some gems. I appreciate that, Isaac. I really do, man. I really do. Out of, I meant these lives are awesome. Thank you, one wise lady. I appreciate it. You will get a lot of the content. Oh, you will get a lot out of. Okay, I got you. I appreciate that. I really do. I try, y'all. I try. This stuff is exhausting, though, for real. I ain't gonna lie to you. It's exhausting. That Dunn Quixote abatement document explains all that. You just need to read it thoroughly. Don't just use it to send it to get out of a ticket. Read it all. I agree with that. Yeah, make sure you read it. You shouldn't be filing anything in court if you don't know what it say. Don't ever do that. You don't know what to say, don't even file it in there. You need to make sure you understand exactly what it says. I used to do that when I first started. I used to do that. I used to just file stuff that I would see and find on the internet. I would probably edit it, you know, and then I would file it. Didn't even know what all of it meant, just know what some of it meant, and I would file it. But I would never let them know that I didn't know everything in the document that I filed. When they start asking me questions, I would always say something like, "I'm not here to answer discovery questions. I'm here to make sure that this judgment is vacated in good faith." I would say something like that. It's 2 a.m. down under. Ooh, it's 2 a.m. over there? I would be asleep if I were you. That's how I learned the difference between using a demur and a motion to dismiss. I think, if I'm not mistaken, a demur and a motion to dismiss they generally are the same thing. If I'm not mistaken, the procedure might be a little different, but I believe they're the same thing, SG. Dog will take us on arrival, then I can arrange where I can meet you at the front gate at Plains to get you those documents. Okay. Ah, I see. That's good though. I see. I didn't know that. I didn't know that, SG. I didn't know that. So you're saying the authentic term for a motion to dismiss is essentially a demur, and it's a common law term. It must be a Latin term or something like that. A motion to dismiss is treated as if you are not challenging personal jurisdiction. Well, I would disagree with that, because in a motion to dismiss, you can challenge the personal jurisdiction. If you're going to read the federal rules of, let me show you what I'm talking about, SG. And this is not to like say I'm better than you or smarter than you and anything like that. So please don't take it that way, because that's not what I'm trying to do. Federal rules of civil procedure. So we're gonna go to federal rules of civil procedure. We go to 12B, and there's going to be subsections in there. I think it might be 12. I don't know. I got to go and look at it. 12B right here. Lack of in personam jurisdiction. So if you were trying to file a motion to dismiss for lack of in personam jurisdiction, you would file a Rule 12B2 motion. Or for lack of subject matter jurisdiction, you would file a Rule 12B1 motion. Or for failure to state a claim, meaning that it's meritless, the lawsuit is meritless because they don't have facts to support their claims, you will file a Rule 12B6 motion. Chancellery. Oh, Chancellor. That's what's up. Look back at the cases you read. They reference to the accused district court. How long? You might be pointing something out that I really ain't been paying attention to. Look back at the cases you read. They referred to the accused. District court still refers to defendant. That's smart. That's smart right there. You paying attention now. That's smart right there. I use so-called accused. DLO, I have to catch up on your video, man. You just missed it. You just missed it. DL, you just missed it. Let me see. I come to this page knowing full well you have way more experience. It probably just I think it's just going to depend on what it is, because I think obviously I would say that you're studying some stuff that I don't study, because I didn't know that about the term demur. It's a word from the jurisdiction of equity. I didn't know that. I appreciate that, one wise lady. I try. I study a little bit here and there on a lot of stuff, but this stuff, law is just it's a vast subject, and you have to take your time, man. Same, but we all have something to bring to the table. Yeah, that's true. That's true, man. We all do. I want to do a 42 section 1983 complaint live on the air, though. Just the ultimate fact section. I want to draft it. Remember that video of the congressman representative that wouldn't cross the bar and corrected the judge every time she called him a defendant? She started correcting herself and called him accused. I think you was that video on Yusuf channel? Because I think I remember seeing a video like that on Yusuf channel. Or it was somebody else channel. I think I know when he is that the video when the man was saying that the seal behind the bench was a corporate seal? I believe that's the video you're referring to. Okay. So I got to figure out what the defendant is. So it must be some sort of presumption then. You have exceptional court process skills. I appreciate that, one wise lady. I try. I don't have all the answers. He talked real loud. I don't have all the answers, but I know how to find these cases. Man, I read cases, y'all, they will blow your mind away, man, from the stuff that I read. They moved on to another case, and he wouldn't leave. But when he's saying that was a corporate seal, he's not lying, because they corporations. He is definitely not lying. They corporations. So it begs it allows you to reasonably conclude that if they corporations, that essentially they don't have any judicial authority outside of I mean, well, I mean, they still, if they weren't corporations, they still don't have judicial authority unless they were created by the state constitution. So that's just really irrelevant. That's just really irrelevant. Oh boy. That's the Nevada Supreme Court case. The General Assembly has seen proper to interfere with the right of the citizen to follow his ordinary vocation only to the extent of prohibiting him from pursuing such calling. Man, what is this? The right to pursue any lawful business or vocation in any manner not inconsistent with the equal rights. Well, y'all got to go and read the old cases, boy. They be having some good stuff. Let me see. The right of any person to engage in business or to pursue. Let me see. The right of personal liberty and the right to earn a livelihood in any lawful calling and to pursue of the ordinary. What is this? These are different Supreme Court decisions, but I want y'all to see that these are principles and that they're basically saying the same thing in each of these cases. On the contrary, the words residents and citizens are both used, and each apparently in its ordinary. Well, let me go and see what they talking about here. I hate when they do this. Be blocking out some of the good stuff. Have to go and read that. That it did not constitute discrimination between men. What are they talking about here? Have to go and read this stuff. But anyway, I gotta go, y'all. I'm tired. I might come back and do another live today, man. He was keeping it out of the district court as the straw man. They prevented personal jurisdiction. That prevented personal jurisdiction. They moved on to another case. They are not on the same. They're not one and the same defendant you never want to be. They all know the truth, but swear they never disclose it to the public. But swear to never disclose it to the public. All right. I'll schedule another live tonight, and we'll take some phone calls, I guess. And we'll just go from there. And if anybody have any, if anybody want to ask any questions or something like that, we'll take some calls. But hopefully, if anybody has any Fourth Amendment lawsuits, like I want to draft one on the air. That's what I want to do. So hopefully, if anybody has one, please contact me, and we'll see if we can get it done. The name challenges are challenging to personal jurisdiction, attempts at it anyway. I agree with that. That legal name, yeah, I agree with that. That's their property. It's within their corporate territorial jurisdiction. Thanks to you and for everyone here for all of this knowledge. I appreciate that, AC. I really do, man. I really do. Focus, I appreciate that. Also, Focus. I'm not sure if that was you or somebody else. I think it was you. I sent you an email in regards to the draft class. I'm not even sure if you got the email, but I'm not even sure if you registered. If you registered, I don't know if you paid the deposit. I don't really know. But when you get some time, Focus, shoot me a message. I'll try to message you today and see. Before I go, I gotta promote my channel some more. So listen, y'all. If you want to learn how to draft paperwork and all this other stuff, do legal research and stuff like that, please come to draft class, okay? Or at least watch my free videos on YouTube, okay? Draft class is $200. It's going to be for 6 days. It's going to be for 3 days, Monday, Wednesday, and Friday, for 1 week, and Monday, Wednesday, and Friday again, another week. It's going to be 18 hours, and it's going to start at 7 p.m. Central Standard Time. All right, and I'll record the classes. For everybody who attends the class and pay for the course, I'll give y'all the videos for free. And the other ones, I guess I'll just sell them or something like that. I don't know. It just depends. I try to make this stuff very affordable for y'all, but I really, really advise y'all to come to class because I don't know what you need help with. So I may not answer a question that you need answered in the video, and you'll probably just be wasting your money buying the video because I didn't answer your question. All right, so I would really just advise y'all to come to draft class. Please come to draft class. This is not about money. I don't care about money, but obviously I do need it because I got bills to pay, and I also want to get paid for my time and experience, and so on and so forth, like that. So, yeah, tired. Okay. One wise lady said, "I've got my deposit." Do you know how to Well, I guess I have to read y'all the instructions because I forgot them. Is an attorney required to submit a written notice of appearance when they represent someone? If I'm not mistaken, they are SG. They got to file they got to enter a notice of appearance. I know they have to do it in the federal court. I'm not really sure in state court, but I know they have to do it in federal court. And then it really just depends on where you at, because some states, they might not care if you do it or not, or whatever. I sprained my, I'm sorry to hear that, folks. Sorry to hear that. Give me a few days. Okay, cool. I think I'm dealing with some court tricks. Why you say that, SG? I think they file appearance. That's what I heard when I used the law. Yeah. I'm of the opinion, I'm not really sure about the state courts, but some state courts do. They do file notice of appearances, but I know for a fact that the Fed does it, and I think they do it all around, like all over the board, all over the country. I think they do. Give me a second, y'all. I'll be right back. I've been on here almost 3 hours. I gotta get off here. I wanted to join to support, just don't have the funds at current. I appreciate it, Philip. I really do. Let me show you this, Philip. You can support like this, man. No notice. Showed up as a court appointed for a civil matter in the first hearing. Oh wow. Nah, I don't think they can do that, fam. You gotta object to that, fam. You don't even know who you dealing with. They might be they might be sent in there to sabotage your case. Yes, they have to do a notice of appearance, not for themselves though. All courts have to enter notice. Okay, Philip, you can support the channel like this. Let me show you. You can do a this right here, Philip. Right here, $1. Juror members, $1. I don't even get the whole dollar. I get like 70 some cents or something like that. I intentionally made this $1 for people because I know some people just can't afford this stuff. I get it. That's why I intentionally made it $1. Because who don't have $1? You see what I'm saying? So you can do it that way, Philip. All you do, just hit join, and then the information will pop up, and you just put it in like that. Where I forgot what I was doing. I got a headache. I gotta go. But if somebody comes up with a way for with a good Fourth Amendment case, please contact me. Send me an email, whatever you have to do, because I want to draft the ultimate facts section of the complaint online for everybody to see. I hired a court reporter for the second hearing, and she showed up again. She was stuttering and sounded nervous and kept looking at the court reporter the second time. Man, these folks, what What kind of case you got going on? What civil case is that, SG? You must be on to something now. They don't want you to talk about something up in there. What kind of case is that? What's the nature of that case? One 149 and odd. Oh, it must be a little. It must cost more right there. All right, you said you have a good Fourth Amendment case, SG. That's what you're saying. If it strictly relates to the Fourth Amendment, uh, child support with due process. Okay, that's a Fifth Amendment custody. That might be it sounds like a mixture of Fourth and Fifth and 14th Amendment. That's what it sounds like to me. Okay. Nah, because all the other stuff is gonna confuse people. I want to stick to the Fourth Amendment in regards to that one. That's what I want to stick to. Child support with due process. It's all funny money. Let me get off here. Y'all ain't finna keep me on here all day. Let me get the hell up off here, man. Thank y'all. I appreciate everybody's support. Again, thank you, Philip, Focus, Wise Lady, SG. I appreciate everything, man. I'll try to come back and do another live a little later today, y'all, and we'll just go from there. Everybody enjoy your day. I'm gonna go ahead and get off here, man. Peace. Ugh.